Hi, this is Dr. Ishita Sharma, and in today's lecture, we are going to discuss the meaning and definition of torts. The customary laws in India, like the Indian and Muslim laws, from the ancient time, did not give much emphasis on the tort law and its development. They focused on the criminal penalty for most wrongs and offences committed by people, and the minute matters of civil nature did not call for damages because of the societal setup that existed. The English law of torts, as it is currently applied in India, was determined to be appropriate for Indian circumstances and was changed by acts of the Indian legislature. Its inception is connected to the founding of British courts in India. In order to decide matters according to justice and right, the British officials in charge of administering these courts typically referred to English common law and statute law that they judged appropriate for Indian conditions. Due to this, the English common law and statutes that were in effect at the time, as well as the civil law system, were introduced into these courts and made suitable to Indian circumstances. The Indian courts, however, can first determine if any rule of English law is appropriate for the Indian society and circumstances before implementing it. The reason the tort law was adopted in India was because it embodied the values of equity, justice, and good conscience. As norms of justice, equity, and good conscience, the English legal system has only been applied selectively in India. The tort law in India stays an uncodified law, which leaves a lot of room for it to be interpreted on circumstantial basis, on the basis of different statutes, precedents, and cases. Now, the conventional Indian legal system, however, provided serious penalties to offences of certain intensities and higher. It lacked the accountability on civil and compensatory grounds. Therefore, the development of law of torts gave rise to a more structured and definite liability in matters of civil injuries. The progression of a more economically and civically stable society called for a system that would compensate for the monetary damages as well as legal injuries that are caused to the aggrieved. Therefore, tort law proved to be very instrumental for the evolution of the outdated legal system driven by customary laws. The compensatory nature aided in civil vigilance and social responsibility to prevent misconduct from the side of the citizens. The compensatory nature of torts also aided the victims to restore monetary losses caused as a result of the legal injury and uphold their personal and public rights. Now, coming to the origin of this word tort, it can be traced to the Latin word tortum, which denotes an act that is inherently twisted in nature. It now denotes a violation of a duty that is not related to a contract, but it results in a civil action from which damages may be sought. A truly appropriate definition of tort still needs to be developed despite numerous attempts. In order to provide a useful description in general layman terms, a tort may be described as a civil wrong unrelated to contracts for which an action for uncomputed damages is the proper solution. A tortfeasor, also known as a wrongdoer, is someone who commits a tort, which is defined as an unlawful conduct. The recompense of victims or their dependents is the main goal of tort law. The obligation to respect the legal rights of other members of society is mandated by law. And anyone who violates this obligation is said to have committed wrongful conduct. In common law systems, the term torts refers to an act for which a civil remedy lies in a court of law, or wrong, as well as a body of law that deals with the task of imposition of liability for acts of such a nature. The legal obligations to abstain from causing any kind of injury to another person, and if injury is caused, to recompense for it or account for it, are imposed not by consent but through sole application of the uncodified law of torts. Socially, the purpose of tort law is to distribute a person's loss to the individual who is believed to have caused it or been accountable for its occurrence, as well as in some cases to diversify the loss across an entire company or even a community. The tort, due to ambiguity in its structure and codification, becomes a tough legal problem to gauge what does and what doesn't constitute a tort. In most jurisdictions, the extent and intensity of various offences categorized as torts varies. However, there is no homogeneous way to identify torts. These fundamentals can also be called as the essentials for torts. Now, these essentials help us to provide a framework of rules to give rise to the tortious liability. These help in creating a balance between the injured party's damage and the liability of the defendant for the same in order to aid smooth functioning of this wing of civil law. Coming to the definition of tort, tort is a French term which means wrong in English. As already mentioned, origin is from the Latin word tortum, meaning to twist or a twisted or a crooked conduct. The basis of torts is ubi jus ibi remedium, meaning thereby, where there is a right, there is a remedy. This maxim is the foundation of the law of torts. It is a fundamental principle that no wrong can remain without a remedy. A right without a remedy is toothless. The court in Ashby versus White recognized the principle and held that if a person has a right, he must have the means to vindicate and maintain it. The law of tort is based on English common law. It is basically the product of judicial decisions. The Supreme Court of India in Rajkot Municipal Corporation versus Majnuben Jayantilal Nakum in 1997 held that in absence of statutory law with respect to torts, common law principles evolved in England may be applied in India. Various jurists have given varied definitions of torts. Some of them are also worth mentioning. For instance, Salmond. It is a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligation. Salmon's definition is accurate but not flawless, and it has some drawbacks. It is oversimplified to conclude that a tort is a civil wrong, when the term civil wrong itself needs clarification. Furthermore, a single conduct may result in multiple civil omissions, one amongst them being a tort and the other such as a contract breach. Now, when an act is of such a dichotomous nature, that is both a civil and a criminal wrong, the recompense of both the categories may simultaneously be available to the victim. What about willful interference with legally protected interests, such as the right to physical safety, psychological peace, or autonomy over property? Is this a civil wrong or a criminal offense? Unliquidated damages are a possible solution, but not the sole solution. There are varied remedies in the nature of restoration of property, prescription, and helping oneself. As a result, Salmon's definition is a very constrained one. It is consistent with his pigeonhole theory, which holds that any harm must fit into pre-established pigeonholes in order to constitute legal damage. Salmon claims that the torts have been classified and any wrongdoing must fit into one of these classifications or pigeonholes. There is a law of torts that is no straight-jacketed theory of liability. Now, this is in stark contrast to Winfield's thesis that all civil harms are actionable and that numerous injuries resulted in numerous lawsuits. Coming on to Winfield, he says, tortious liability arises from the breach of a duty primarily fixed by the law. Now, this duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. As per Fraser, it is an infringement of a right in rem of a private individual, giving a right of compensation at the suit of the injured party. Additionally, we have a definition under the Limitation Act 1963, more specifically Section 2, Subclause M, which defines tort as tort means a civil wrong which is not exclusively a breach of contract or breach of trust. These definitions allude to two fundamental ideas. Tort being labeled primarily as an act that is civil in nature, and number two, every civil wrong is not a species of tort. Tort is the genus of which a civil wrong is not always a species. For instance, there are more civil wrongs, the most significant of which are a violation of faith, or what we say in legal parlance as trust, and a contract. The damages in torts are not predetermined and are computed at a later stage in a code of law. Now, coming to some basic concepts that are intricately related to the meaning of torts. Tort versus torts. The definition of a tort according to the law of torts is any unlawful act for which there is neither a defense nor an explanation. Winfield supported this view because, in his opinion, if wrongdoing occurs without explanation, the offender will be held accountable. Thus, Law of Tort is the title of Winfield's book. The law of torts, which is minute in nature with certain delineated wrongs, over which this area of law's culpability cannot apply. Salmond supported this idea because, in his view, culpability only exists when the wrong committed falls squarely within one of the delineated wrongs. Pigeonhole theory is another name for this hypothesis. Thus, Law of Torts is the title of Salmon's book. Coming to the essentials of torts, which are the typical elements of imposition of culpability in torts: the defendant's action or inaction, the act or omission which violated the plaintiff's legal rights, causing legal harm. A person is liable in torts for dichotomous acts of omission as well as commission. The act must involve a negligent or unlawful action. If someone violates a legal obligation to do or abstain from executing something, they may also be held accountable in torts. A tort action cannot be brought unless the plaintiff's legal rights have been violated, in which case the plaintiff must demonstrate that he has incurred financial harm as a result of the defendant's act or omission. Now, there are two maxims that govern the law of torts: injuria sine damnum and damnum sine injuria. It's critical to look at whether the plaintiff's legal rights have been infringed in order to assess tort culpability. It doesn't matter if he actually suffered a loss if his legal rights were infringed. The dictum injuria sine damnum supports this perspective. Injuria denotes the violation of a legal right. Sine means without or absence. And damnum denotes the gravity of loss, failure, or damage. The behavior is the prime source of culpability in torts, which results in the infringement of a legal right. And how is it compensated? That is compensated irrespective of the fact that the act has actually resulted in inflicting any harm upon the victim. According to a related dictum, damnum sine injuria, it is possible for the plaintiff to suffer an actual or significant loss, occasionally, without having his legal rights violated. In such circumstances, a tort claim is not warranted. This typically occurs as a result of performance of a legal right that results in a consequential injury to the other. Despite the presence of mens rea in carrying out such an act, no remedy lies in these situations. Plummeting of business by individual traders as a result of trade competition is a best illustration of this. This theory is based on the idea that carrying out daily tasks without engaging in a number of actions that are somewhat likely to harm or annoy other people is not conceivable. Therefore, the law does not take into account every possible type of injury or damage. Now, let us see some examples of torts law. In February 2016, a Google autonomous vehicle struck a bus in Mountain View, California. Now, these artificial intelligence-enabled vehicles were the novelty of the day. It noticed a group of sandbags encircling a storm drain and veered into another lane to avoid them, crashing into the curb. For the first time, an autonomous vehicle actually caused the collision rather than just being engaged in it. Liability in tort law allows drivers to bring a lawsuit against a manufacturer for a faulty motor part, such as an airbag or a tire. However, because autonomous vehicles are now covered by this liability tort, Google and other participants in this emerging sector may also be charged with guilt and held accountable. Let me cite an example of a negligence case. Amy Williams sued Quest Diagnostics and its affiliate Athena Diagnostics for negligence following the passing of a son, Christian Miller, who was just 2 years old. A Miller's gene mutation was incorrectly categorized by Athena Diagnostics in 2007. The complaint claimed that the misinterpretation caused the child's doctors to treat his symptoms incorrectly. The seizure and his untimely death were a direct concomitant of the incorrect categorization. The South Carolina Supreme Court gave the dictum in 2018, 11 years after the kid had passed away, that a genetic testing facility might be regarded as a center of healthcare under South Carolina's tort law. Now, an intentional tort case. The March 18, 2016 judgment between professional wrestler Hulk Hogan and the website Gawker serves as a classic illustration of a tort committed deliberately. Since it was determined that Gawker purposefully breached Hogan's dignity in order to get video proof of an act that was confidential, Hogan was given $140 million in damages. The well-known Union Carbide case is an Indian tort case. Methyl isocyanide, a highly toxic gas that was released by the Union Carbide plant in Bhopal, Madhya Pradesh, way back in 1984, which killed hundreds of people on the first day of the sad, tragic incident. The incident resulted in long-term medical consequences such as eye issues, respiratory issues, immunological and neurological illnesses, cardiac failures, birth deformities in unborn children, as well as the loss of thousands of lives. Even though Union Carbide did not have a contract with the individuals who suffered grave damages as a result of the company's negligence, Union Carbide was still held accountable under tort law. So, all these cases make one point very, very clear. Tort is a civil wrong. Now, let's talk about the several theories that are related to the meaning of torts. Firstly, the eggshell theory. The legal theory of causation, known as the eggshell theory, holds that a tortfeasor must take their victim as and when they are found. Therefore, the culpability will still be imposed on the defendant if the harm suffered by the plaintiff is of a greater proportion as a result of a prior disease than a typical person would. Now, for an illustration, let's suppose our client has a blood disease that makes her more prone to bleeding and bruising than typical people. The plaintiff's injuries as a result of a car accident that involved the defendant are far worse than would be anticipated given the accident's minor impact. In actuality or in reality, the majority of regular people might have simply avoided harm by just being cautious. However, as a result of this event, the plaintiff needed blood transfusions and had to spend 2 weeks in the hospital. According to the eggshell theory, even if the plaintiff's harm was not foreseen, the defendant's acts would still be to blame. Now, coming to another theory, which is the pigeonhole theory, or the Salmon's theory of the law of torts. Salmon argued that if one person does something wrong, and that wrong can be classified, or he claimed that there is no universal principle, and if the plaintiff can somehow classify that mistake in the pigeonhole that is branded as a tort, then the plaintiff may be successful. He adds that just as criminal law clearly lists certain violations, tort law should also describe specific injuries that may be legally supported and confirmed. There isn't one overarching rule or an umbrella term that applies to all tort cases. He contends that only a limited number of clearly defined wrongs should be classified as torts and placed in the so-called pigeonhole. He opposes the notion of treating tort law as an overarching principle. He continues by saying that only for wrong that fit under the precise definition of torts will a remedy be accessible. He used the term analogy of pigeonholes to better effectively convey this notion, with each wrong falling under a narrower category like negligence, assault, battery, deceit, or slander. And the concerned evil does not fall into one of these categories. It is not a tort. Many claim this attempt of Salmond as limiting the contours of the law of torts when it is growing at a rapid pace. This claim is supported by the facts of the Donoghue versus Stevenson case, where a complaint was made against the seller when a snail was discovered in the remnants of a ginger beer bottle. The maker was held accountable for the negligence rather than the owner because the injury could not have been anticipated. And a brand new set of guidelines was developed, stating that everyone should value their neighbors and refrain from supporting any actions that endanger them. In response to the aforementioned claim, Salmond argues that just as criminal law has specific, enumerated, and well-defined offences, tort law too has specific wrongs. Thus, being a pioneer of the law of torts. Now, if I have to just sum up, there are two ways to decide if something falls under tort law or law of torts. One is the pigeonhole theory, sometimes known as the Winfield theory, and the other is the Salmond theory. We can infer from these two hypotheses that the former is an encompassing idea and the latter is a more focused concept. Winfield claims that both the theories are true, but it all relies on interpretation, on how we interpret them. One being a more general idea that allows for the creation of new torts. The other is a more specific concept that only allows for the plaintiff to seek damages for those wrongdoings that fall within the label tort. Which one is best depends on the individual, which preferably depends on the individual concerned. But Winfield's theory is employed because of its more comprehensiveness. Winfield's theory is preferred even by the Indian judiciary since it allows for the creation of novel torts, as we have seen in the case of absolute liability. In England, the idea of law of torts has attained maturity. This law's primary goal is to offer compensation to the victim of a right infringement. It also serves as the criminal justice system's second hand by giving out exemplary damages. In the United States, the United Kingdom, and many other nations, this idea has achieved fame and security. However, India continues to be developing this branch of the tree. The judiciary, legal system, and public are all involved in this development. With this, we come to the end of today's lecture. Thank you very much.